Pybus University, where learning is a lifelong adventure. The Pybus Public Market is pleased to offer a series of unique and fun classes for the Wenatchee Valley community. Classes are taught by local volunteers with an interest and aptitude in the subjects that they teach.
Thanks so much. Thanks everybody for coming tonight. Again, we just want to give you kind of a little bit of lay of the land of what we're going to talk about tonight, and we're just going to have a nice conversation. And so we're happy to answer questions at the end, and to let you know that you will be recorded this evening. This is something that our local television station does, which is great. So tell your friends, they can catch it on the NCWLIFE network later on, and check out and see what you saw in person. So again, we want to thank again all of the professionals that are here tonight. They're going to be around, and so after the presentation, if you have questions, you want to introduce yourself, get to know them a little bit, they're here for you this evening. So let's get started with this. What do you think, Colleen? You ready to go? Does your mic work?
Sounds good. Oh.
Not yet. We'll get this going. Oh, I think you did it. We can share. You scoot closer. Jonathan will fix this. So we're just going to start out by talking about just the very basics of what is estate planning. So Colleen, what is estate planning? What does that even mean?
Beth, that is a great question. So estate planning is essentially the phrase to cover taking care of your affairs, from your financial, your household, your medical affairs, and directing someone else to really carry out your wishes. It's that magical phrase that is used to encompass getting a will in place, power of attorney, healthcare directive. It's that word that just means taking care of things during your lifetime and upon your passing. So, and you know, we're all here tonight because each of us want to learn some more about estate planning. You know, perhaps you have a will, maybe you don't have a will. Maybe you did a will 20 years ago and you're thinking it's about time to update it, or potentially something happened in your life that you want to renew your estate planning documents. And so that's why we're here tonight, is to learn more about estate planning, which is something that's so near and dear to my heart, given the importance of making sure your affairs are in order so you have the chance to decide how things are going to be handled and taken care of, instead of leaving that up to the courts or maybe a family member or someone else who may not know exactly what your wishes are.
So how many people here have a will in place already? Oh my gosh. You know, I think that you are outstanding, because if you look at the statistics about the number of citizens in our country that don't have a will, and it's almost 90%. So this group of folks, you are way ahead of the curve, so well done. But Colleen, so we've got a very good audience here. They've already stepped into the fold. Why is it important that they keep their affairs in order, or why would it be important for them to continually update a will?
You know, too many times I feel like either we've experienced it in our own lives, or we've heard from a friend or a neighbor who has gone through a very difficult time of losing a loved one, or having a loved one who has needs that cannot be addressed, and that loved one did not give enough forethought to put their affairs in order in estate planning. And that possibility of either being placed in a vulnerable situation, you know, maybe on a loss of capacity, or upon passing away and they don't know who gets all of the, you know, who handles the household and who's supposed to be in charge. That can be so difficult, and you know, there's already enough emotion that goes into when you're faced with those situations during your lifetime or upon someone's passing, that really taking care of it and avoiding those consequences are kind of the easiest. One of the key things that I always like to think about is, you know, the two different aspects of estate planning. You have estate planning during your lifetime. So what happens if all of a sudden you can't express your wishes, or you're not able to? Maybe there's, you know, dementia or memory loss, or maybe there's a medical situation and you are no longer able to express your wishes. So you kind of have estate planning during your lifetime. Then there's the estate planning upon passing, and that's the will that most people are often thinking of. You know, I'd say one of the key consequences, Beth, for when you're thinking about estate planning during your lifetime is being able to make those medical decisions on your behalf if you can't share what that is.
So can you talk a little bit more about that? What are the tools that we need to have in place specifically around those needs that might arise if we are incapacitated or we have some medical needs that someone has to make decisions for us?
Yeah, so I'd say the key documents that we as attorneys kind of talk about and think about for estate planning during your lifetime is that general power of attorney. And that's really the document that says who's going to manage your financial, your household affairs during your lifetime if you're not able to. And then you also have a specialized power of attorney for healthcare decisions. And that is who are you directing and asking to make those medical decisions if you can't express your own wishes. And that healthcare power of attorney, Beth, is often accompanied by what's called a healthcare directive, or also known as a living will. And so that's where you're actually saying, in the event, there's a terminal condition, my medical desires are XYZ.
So can you give us some examples that you've seen in your practice? Because as we know, you've been practicing for quite some time, and I'm sure that you've had a few stories or horror stories in some cases. And so give us some examples of why it's good to have this in place.
Well, I think maybe one of the biggest high-profile examples that I can think of is the Terri Schiavo case that a handful of you may have remembered from a few years ago. And that was a situation where Ms. Schiavo, at an earlier age was, had a horrible accident and went into a coma, medical coma, and her husband and Terri Schiavo's parents were embroiled in this legal battle that spanned years and years over what should be the medical desires for Ms. Schiavo. This matter was highly publicized. The legal battle went through state and federal courts, even up to the Florida state legislature, U.S. Supreme Court. Even President George W. Bush got involved in it at one point. And so that was something that, although everyone had what they thought were her best wishes in mind, Ms. Schiavo did not have that power of attorney for healthcare in place saying who she wanted to be the person making those decisions. And so her family was faced with having to decide it through the courts.
And also, you mentioned the healthcare directive. So same situation. She could have said, if I am in a coma, I don't want any extenuating circumstances or for this to carry on for a long period of time. So having those desires put into writing as well is important.
Correct. And one thing that I've noticed that's really fantastic about our community here, and especially our medical community, is when you have kind of your regular physician, they often ask you if you have a healthcare directive, if you have a living will, if you have appointed a medical power of attorney. And I think that's really useful that even our medical professionals are interested and involved in making sure that each of us are cared for if that situation ever comes to light.
Pybus University, where learning is a lifelong adventure. Pybus University, where learning is a lifelong adventure.
What are some things that we should be thinking about when we think about putting people in those positions? Do you have any recommendations on how we think about that? Is it always the same person? Are they different people? Is it always family? Is it friends? Strangers on the streets? I mean...
Well, Beth, I definitely wouldn't recommend having a stranger on the street serve in that role. But really, it comes down to the individual or individuals that you have that trust and confidence with, the people that you think could carry that out. And that doesn't necessarily have to reside in one person. You could have your financial power of attorney and you could think, well, my spouse is excellent at record keeping. They do a wonderful job with the books. They know how I want to run my affairs. And so that's the person I'm going to appoint. But then when you think about your medical power of attorney, you could possibly in the same breath say, I think that might be too difficult a decision to ask my spouse to do. And maybe I have a family member or a friend who would be able to serve in that role. Or perhaps I don't want any one person to have to make that decision, and so I'm going to ask two people to serve in that position together so they can work together as a team and resolve the matters that might come up during my lifetime.
So you've chosen your people. What's the next step? Maybe having a conversation?
That is certainly my recommendation. When I think about the kind of the key things that are so important in estate planning, one is thinking about your affairs, thinking about the kind of legacy you want to leave, and how you want that to be instilled in others. Then getting your documents in place, actually meeting with a professional to do that. And the third item is having those conversations, talking to the people you appointed as the guardians for your kids so they understand what that means. So they understand, well, yeah, I think when, little Johnny's older, I want him to go to college, but I don't think he should get his whole way. I think we should only give him part to help him out for college. And so just having those sort of conversations really helps your fiduciaries, the individuals who are serving in those roles, understand what your intent is. It gives some context to the words in the document. That said, having those conversations doesn't mean you have to share the copies of your documents. It doesn't mean you have to tell them what you're giving to each individual in your will, but you can at least share some thoughts on why you've asked them to serve in that role and why you think they're going to do a good job for carrying out your wishes.
That's excellent. So I know that in a lot of cases that only talking to the person who's going to be in charge of that may not be enough. I've heard of some situations with some friends where a parent was ill and the healthcare directive representative had to make some difficult decisions, and the children were against it because the parent didn't have the conversation with the child. And so when you think about having those conversations, think about having broad conversations about sharing your wishes with everyone who might be involved, at least at a very basic level, and saying, this person is in charge and they know what my wishes are, and so please respect those, because it can be a very challenging time when a medical emergency comes around. So I think that that's great advice. So tell us a little bit, so we talked a little bit about the basics, the power of attorney, the healthcare directive, the living will. Are there any other basic documents that we need to be thinking about? Or is that the core group?
That's the core group for really handling your estate planning during your lifetime. But the critical document for what happens upon passing is the will. And that's the document that I think, although this audience was great, most of you have wills, but for those of you that haven't, it's because it's difficult. It's difficult to think about, what do I want to do when, if I pass away, and am I making the right decisions? Do I even want to think about that? And overcoming those hurdles and even just beginning that conversation is a part of it. And I will admit, as soon as you get that will and those estate planning documents in place, you're going to feel such a relief. There really is this peace of mind that maybe you didn't even realize you were carrying on your shoulders until you have those documents in place. The other thing that's fantastic about estate planning is you have the chance to change your mind as your life and your situation adjusts, or as family members adjust. Maybe you have a certain will when you have small, minor children, and when they get older, you see the great human beings they've grown into, and you make different decisions in your will. And so you have the chance to update and amend your estate planning over time.
So many people think that estate planning is very complicated. We hear lots about these very crazy trusts and things that people are doing. When do you know when you need something very simple versus something very complicated?
Well, certainly having a conversation with a professional, with your financial advisors, with an attorney is going to help make those decisions, but most of it is based off of your own goals, what you're desiring for your future and for that legacy you want to leave. The idea of a trust gets floated around a lot, and Trusts are very useful tools when they're necessary. When you have a family situation or a beneficiary that needs some additional protection or assets need to be held. Again, a great example is if you have minor kids, you probably don't want a 13-year-old to inherit your whole estate. So you're going to put the funds in a trust until they're a little older and maybe a little more sophisticated.
You mentioned special circumstances. So talk to us a little bit about special needs trusts.
Yeah, so special needs trusts are a really wonderful tool. In Washington State, we have the benefit of having some really robust estate planning around special needs trusts, where if you do have an individual, a family member who is receiving governmental benefits, or maybe there's another reason why you would want to preserve assets in a trust for them, you can use a special needs trust. And that's a fancy way of essentially saying the funds are held, someone else is monitoring and administering them on behalf of that special needs beneficiary, and still allowing that special needs beneficiary the benefit of the trust without jeopardizing their assistance from the government.
Pybus University, where learning is a lifelong adventure. Pybus University, where learning is a lifelong adventure.
So maybe let's take everyone through a little journey about you walk in the door to visit the attorney. What does that look like?
Well, hopefully you've already done some preliminary thinking. Maybe you're needing to update a will and you've thought about who you might select to be your personal representative or executor. Those two words are the same thing, they've just kind of been updated over time. And maybe you've also thought about how you would want your affairs to be handled. You've said, I would like to make sure I'm insuring something for my family. I'm also wanting to make sure I leave a legacy to, maybe my favorite charities in town. But really to have those opening conversations and an awareness of your financial base. Part of that is going to be determining the complexity of the will and the estate planning with tax planning, if that is something that's one of your goals and objectives.
So, okay, so we get my will, I've got my power of attorney and my healthcare directive done. And so let's say that my life ends and we hear this thing all the time banted around about probate. So what happens when my life has ended? What starts then? What does that look like? What's that process look like for that person that has agreed to be my personal representative? So
for your personal representative or anyone, do I have a show of hands of anyone who's ever served as an executor or a personal representative before? So a handful of us have been through that process.
And how many of you thought it was a great job?
It's not, it is a job. I would definitely say that. But it can also be much easier if you're working with good professionals. If you're working with your CPA and working with the attorney through that process, that it can be a little less painful than if you were doing it on your own. But probate is similar to estate planning. Probate is that phrase that we use to talk about the court process of taking a will from someone's passing away and making sure that the assets get distributed and the will gets carried out. And so when you have a probate, the personal representative is there to kind of marshal and learn as much as they can about the assets of the person who's passed away. They're looking at the will and they're to carry out the intent. They're to say, okay, this will says these 5 people are to receive all of the personal effects in the household. Well, let's make sure we take care of that. And now the will says I need to give 10% to North Central Washington Community Foundation. And so the personal representative is working to make sure that those things happen. Probate process is, again, a process. You're going through court administration, But here in Washington State, it's fairly straightforward. It's not too onerous of a process. You can work through it. And it's the sort of thing that the filing fee is minimal. Here in Chelan and Douglas counties, it's $240 to get a probate opened. And I mention that because we hear a lot of information out there, you know, on the internet or in the news of trying to avoid probate. And that's true for some states, like the state of California, where the state takes a percentage of all the assets. And so that's something that people go to great lengths to try to avoid because they'd rather pass on their funds to family members or organizations instead of having that percentage go to the state. But here in Washington, it's a flat fee to do that probate process. And so your will does get carried out to all the people you wanted it to.
Is there a timeline that you have to do that within?
There are some timelines, and it's under the Washington law. There's a statute on, you know, when a personal representative should be filing a probate after a passing, but nothing is required to be done immediately. I'm always surprised when I receive a phone call from someone that says, you know, their loved one passed away that day or yesterday, and I'm shocked that they're calling me because there's time for you to just process and grieve and be with your friends and family. You don't need to call your attorney the day it happens or even the week it happens. You have time. But I also understand that for some people, that's their way of taking care and managing affairs. And so I don't turn them away. I just want you to know that you don't have to hop on legal issues. You have the opportunity to just continue and process your life. So,
have you ever run across a client that has done an exceptional job with their estate, getting it ready for when the personal representative would take it over? Are there some tricks or tools that you would offer folks out there to make that gift that person has agreed to be their personal representative a little less painful?
Yeah, I definitely would say are kind of those 3 key items, and that is to understand what you're hoping to accomplish, what legacy you're wanting to leave. You know, when you think about the values you want to pass down to your family members and to your friends, and then coordinating your estate planning so you can carry that out. You know, that's probably the first thing. And the second thing would be then working with the professionals, you know, working with your financial advisors, working with their attorneys. And there are so many great resources in town to do that. The Volunteer Attorney Services is a tremendous asset here in our community that does estate planning clinics. They even have a Veterans Will Clinic every year for estate planning with people who have been in the armed forces. They do free estate planning for them. The Community Foundation, I have worked with Beth many times and have seen some really successful estate planning and people's dreams being carried out through the Community Foundation. So getting your estate planning in place. And then the third thing, again, is having those conversations, you know, talking to your family members about what you're hoping to accomplish with this and why maybe you've selected that individual as your fiduciary to serve as your power of attorney or to serve as the trustee for your children's trust and what you're hoping to do with them in that role.
I think that's a great point that, you know, so often we think of a will and, you know, we've talked about these very specific legal documents and they're legal documents. They don't typically lend themselves to passing down those values and the more important things. And so I think that's great that you brought that up, that you can have an estate plan that includes those pieces. I know that when the Community Foundation was the beneficiary of an estate and the personal representative came to us and talked about how he was having to go through boxes in the basement to find records and things like that. And so I think that there's some things that you can do, you know, when you're talking to that person who you've asked to be your personal representative and maybe sharing with them, you know, here's where you can find my bank account information and here's where you can find passwords and things. And because I think that that's, in this world that we live in, it's becoming more and more challenging to just kind of unlock, if you will, all of the resources that someone might have if they're not easily recognizable. Have you ever run across anything where some good tips or tools around that?
Yeah, certainly, as Beth just mentioned, making sure that the fiduciaries that you've selected know where to find things. If they know it's in your file cabinet, you don't have to show them the documents. They don't have to know the passwords ahead of time, but they know where to go. There's always this, I don't know if it's an urban legend or not, but about a will where in the will the gentleman discusses how he wants to be cremated, but he didn't tell anyone in advance, and the family read the will after the big open casket ceremony. And so, you know, discussing those items with your fiduciaries so they know in advance what your hopes are, or if you have some things set up in place, if you already have, you know, funeral wishes, or I remember as a small child being in the middle of church and my mom saying, "Oh wait, this is the song I want in my funeral," and you know, that sort of thing has stuck with me my whole life.
But I think those are the important conversations. I mean, that we all have in our heads things that we want to see happen, and unless we share those with the people who we're surrounding ourselves with, that's not going to happen. You're going to end up with the open casket instead of the cremation. So.
Pybus University, where learning is a lifelong adventure. Pybus University, where learning is a lifelong adventure.
Beth, thinking about it, you know, in the work you do with the Community Foundation, you know, what's the best way for someone to really leave a legacy? Even, you know, I think about a lot of individuals that say, well, I'm not rich, I don't have all this wealth of money or assets. How do I still make a difference?
Well, what I would say is that community foundations and charitable organizations all throughout this region are supported by people who none of us would say are rich, because we all think about philanthropy and the Gates Foundation and the Warren Buffetts, and really truly when you look around this country and you look around this community in particular, the people who do give and give generously are people just like you and me. There are teachers, there are people who work in our communities, there are orchardists, and I can tell you story after story about people who have left a legacy with the Community Foundation who you would have never thought that they would have done something like that. And today they're supporting students going to college because that was important to them, or they're supporting their church. You know, they've given gifts all throughout their lives to their church, and they want to make sure that the church is still given their generosity after they're gone. And so at the Community Foundation, we're lucky enough that we get to do those kinds of things. So I would say everyone in this room has an opportunity to make a legacy gift to support things that are important to them in this community. And I know I love living here, and I know that I have benefited from people who have come before me who have left a gift. And I plan to do the same thing because I know that there are people that are going to come after me, and it's my job to do the same thing, to make sure that we all take care of each other. Because if we don't do it, no one else is going to, and our community will suffer.
So does someone need to include like a specific charity or the Community Foundation in their will, or are there other ways that they can give?
Sure, there are lots of different ways that I think people don't think about. So certainly the estate gift, the bequest, is a very common way that people leave a legacy gift in their community. And what we find is that most people don't just have one charity that they support multiple charities. There are many things that they have loved during their lifetime that they want to make sure they have something to leave to them afterwards, in addition to their loved ones. But also things that we don't often think about. You know, when we're young and we have young children, sometimes we'll have a paid up life insurance plan, and then we forget about it because we're older now and our children are grown and they have their own families. And you know, the purpose of having that life insurance was to protect those kids if we were to suddenly die and they were minors. And that's a gift that can be given to a charity of any flavor at any time. Same thing with designated or beneficiary designations on your IRAs. Oftentimes those are really great assets to leave to charity because if you leave them to your loved ones, you'll be taxed on those or your loved ones will be taxed on those gifts. And so what we see is that if people say, gosh, I would really like to do something for charity, talking again to a professional advisor about, well, what's a good gift to leave to charity and what's a good gift to leave to my kids? You know, maybe there's the house or a life insurance policy or other things. And so really understanding kind of what the breadth of your assets are, because most people have assets of some sort. They have a house, they have a car, and people don't think about that when they think about their wealth. They think about, gosh, what's my checking account? And really we have so much more than that to consider when we're making these plans about what we want to leave our children and our friends and to our community. Do you have any other, I love to tell, you know, case studies around different examples of ways that people can do either charitable giving or be well prepared or structure their will. Do you have any case studies that you would like to share?
Well, I mean, when you think about estate planning and people's wills, I think part of what I love so much about it is that it's unique. You know, every situation is different, every family is different. There's a lot of the same things. We have so many of the same tools. We've got that general power of attorney to handle your financial affairs. There's the medical power of attorney. There's the will. So like the types of documents are the same, but the way they're carried out is very individualized. And I think that's one of the powerful aspects of having estate planning is that you get to decide what's happening. And it's not just falling under the Washington state law if you pass away without a will. Because that's what happens. If you pass away without a will, you're subject to just what the state legislature has said, this is where your assets should go. And that may not be what your desires are. And so your will lets you say, I want to give some additional money to, or a small scholarship to the kid who lives down the street who's mowed my lawn and comes help me rake the leaves every year of his life, and now that he's a grown-up, he still comes back and visits me. I mean, it gives you the ability and the flexibility to do that, which I think is really a phenomenal thing we have. There's also in Washington the ability to specifically write lists for your own personal effects for your household affairs or your household items. And I see that as being also a very critical way to share with those the legacy you want to leave behind. You know, in your will, you may not list out, I want my grandmother's tea set to go to Henry, and I want my father's tools to go to Jacob. You may not say those sort of things in your will because then your will would just be way too long. But in Washington, you have the ability to write a list out and do that. And I think that's really a wonderful way to be able to just continue sharing what you want in your life and what you want to give to others.
So my mother-in-law puts masking tape on the back of furniture. Does that work?
It doesn't, and my mother does the same thing. She does it, my sisters and I, she puts a different colored sticker for each of us, and we tease her that we're gonna go around switching the colors. But no, you have to have it in writing, and it needs to be dated.
Well, that's good to know. All right, very good. Well, we have, we have lots of stories at the Community Foundation about people who have left legacy gifts, but I think I'm gonna talk about one in particular because we have some charitable remainder trusts that we trustee, and these are also really interesting vehicles to both support a child or a beneficiary during their lifetime and then to leave a legacy gift afterwards. And we have one donor that established a charitable remainder trust, and she had a very long history with cancer care in the community. It's the organization that provides housing for folks who are here doing treatment. And so when she passed away, she established a charitable remainder trust, and she has two grown children, but both are disabled. And so the Community Foundation is able to provide them with an income on a monthly basis. And then once those two children pass away, then the remainder of that trust will go to cancer care. And so it was a wonderful way to not have to take care of those adult children without giving them the entire bequest, and also still being able to do a charitable gift after those kids have passed away as well. So I think those are some really interesting things that people do. Like you say, no two are alike. We're all going to be individuals about how we do this, but really spending the time to think through kind of what your values are and what your hopes and dreams are with your estate plan, your charitable giving, what you want to leave those family members, both maybe on an asset side but also on a value side, is I think a really important piece to consider.
Pybus University, where learning is a lifelong adventure. Pybus University, where learning is a lifelong adventure.
Why don't you share with us maybe some of the key things that you like to talk to people about when they're thinking about giving a charitable gift?
So the first thing we always talk to them about is making sure that if they're doing a charitable gift during their lifetime, that they have assets to ensure that they're going to be protected during their lifetime. So we want to make sure that folks don't, because we see a lot of folks that are charitable that really want to come in and they want to start that scholarship now because they want to see those kids going to school. And we want to make sure that that's great, but that they have the assets that they need to live the rest of their life. So that's the first and most important thing. And then after that is, what can we do to make sure that your wishes are fulfilled? And so oftentimes we will get a letter from an attorney that a gift has been left to the Community Foundation with very little instruction. And so we really encourage people, we love it when they come and tell us that they're going to do an estate gift so that we can chat with them and capture what it is that they're trying to do. Because if we get it in the will as an estate gift after they're gone, we can't ask them any questions. And maybe it wasn't clear to us, gosh, do they want just students from Wenatchee High School, or did they want Wenatchee High School and Kashmir High School? It wasn't quite clear. So those are the things that we worry about in our office, is that we're not sure what the donor's intent are. So coming and visiting with us and letting us know, and it's never an obligation, right? As Colleen said, if you decide you want to put a charitable gift in your will today and your circumstances change 10 years from now, or there's a new nonprofit in the organization or in the community that you want to support, or you've changed churches, those things can easily be changed in your estate plan. But making sure that you have them in there is really important. So we talk to folks about that. We also have a will kit on our website, which is cfncw.org. And that's a very robust document that kind of walks you through all the different steps, both around what you want to leave your friends and family, but also what you might want to leave your community. So that's a resource that's free to anyone, and you can just go onto our website and check it out. And it's, I'm sure, total overkill, but some people might really like that.
Yeah, and I mean, to back that up, I know you've heard this a lot from both Beth and I tonight, but it's start the process. If you have a will and you're wanting just to take a look at it, make sure it still covers everything you want, that's the first step. If you don't have a will, talk to your attorney, talk to your financial advisor, so they can help craft and share what you want to do and how you want to leave your legacy. But you just got to start somewhere, and taking those first steps, I assure you, you will feel so great having that relief and just having that peace of mind, knowing that you've been the one to decide what kind of legacy you want to leave.
Well, I think, Colleen, that brings us to probably the question that everyone wants to ask is, how much is this going to cost me? Because, attorneys are expensive. So what would it cost me to do these really important documents that you've been talking about all night?
Well, certainly. As with your estate planning being unique, the intricacy and the sophistication of the planning is also unique. And so where you're talking about really a straightforward, basic set of estate planning documents, you're probably looking at a couple of hours of legal time. And so you have to think about that. You have to budget that and think about how it is an investment in yourself and in, the future that you want to leave. And And then, to the extent you have, special situations or tax planning that goes into it, then it may be more complicated. But one thing that's really fantastic is the attorneys that you meet with will be able to talk with you about that. They'll be able to share with that to say, no, I think this project's going to take me 2 hours of time, or, well, we also have we want to do some additional planning here, and you have these matters you want to address, and so maybe we're looking at 4 hours of time. That's part of that process and the communication, but you have to start the conversation in order to figure it out. It's, estate planning, and the reason why I'm telling you just, start the process is because don't let that be an impediment to you getting estate planning in place. Think about how you're investing that amount of time and those costs into yourself and your family, so they can avoid having to go through, a potentially drawn-out legal battle or other issues that could be way more expensive and certainly more heartache at the end.
Pybus University, where learning is a lifelong adventure. Pybus University, where learning is a lifelong adventure.
But we also wanted to give you a chance to ask your own questions. And so we already have an audience member. Sir.
I have a two-part question. After a death, is there someone responsible to ask the family if there is a will? Like in the city or the state or something?
So one of the things we do here in our local Chelan Douglas Bar Association, where there is a family member who says, so-and-so has passed away, I'm not sure if there's a will, our local bar association sends out an email asking every attorney in our area if they're holding a copy of a will for that individual. And so if you don't run across it in the file cabinet or maybe hiding in the freezer where they kept all their other special documents, then you can always contact the local bar association to attempt to locate that will. And often those get found in someone's files. One thing my office does when we hold wills is when someone passes away, we do reach out to the family members just to notify them that we have a will. And I think many other law firms in town do that as well.
How about retired attorneys?
Those retired attorneys, for the most part, their files get pulled into other individuals' offices for that precise reason, so you can keep and maintain those original documents. So depending on the situation, you can have an estate that does not go through probate, and the statute provides the specifications on it. One of it is where your estate is below a certain dollar threshold. You're not required to go through probate. Also, if there's no real estate involved, you're not required to go through probate. So there are situations where you could have a will or have an estate, but it doesn't go through the court process of probate. So that's a great question, Greg. There is somewhat in the, I'd say, last 2 or 3 years, both a federal statute and then a Washington state statute that mirrors it about essentially passwords and digital access. And many of the companies, like Gmail's an easy example, where they have their own protocols on who can and cannot access someone's password and digital information. And so in estate planning documents, we make sure that we grant the fiduciary that right and authority to get that access. And so you'd be able to take, the copy of the will that says, yes, the personal representative has the ability to access all of my digital accounts, and then the bank that has the digital online accounts or Gmail or whatever will be able to then grant you that access.
So that's a good point. If you have a will that was written in 1980, it's probably time for an update for that little clause alone. So that's a great question. So the question was, if you set up a legacy gift with the Community Foundation, do you do that through your attorney or through the Community Foundation? And the answer is you can do it both ways. We work with attorneys all the time to establish language with the donor, with the client, that would be embedded in the will. And we also have done it where the client comes to see the Community Foundation. We fill out the fund agreement with their wishes in it, and then it becomes an attachment to the will and just referenced. And so that's an easy way to, if you decide again to change beneficiaries, like if you want to support your church and the Humane Society and your alma mater, but maybe you decide you don't like your alma mater anymore, you can just come to us and we can like make a new one instead of having to go back and change the will, and we can just add that in as an attachment. So we've done it both ways.
So the question was, if a family member doesn't have a will and then they're going through the process they're going through is called intestate succession, and that word just means without a will. So intestate, testate being having a will. And so that family member can still, you'd go through a court probate process, but it's the intestate process, which just has some additional restrictions in court oversight because of the fact that the person who is administering the estate wasn't necessarily appointed directly by the decedent, and so the court just watches things in a different fashion, but it's a similar probate process. The issue and the concern is that you don't have the benefit of the will. You don't have the benefit of knowing if that individual wanted to do something different than what's set up under the Washington State Intestate Succession laws, which is what you're carrying out in the event that someone passes away without a will.
So the state of Washington then...
So the state of Washington sets up who receives what under the will. It's under Washington state law. To the extent you have all that background information, it's certainly useful. As with any appointment, the more information you bring to it, kind of the better informed you are to be able to have discussions or look at different ideas. But the key thing is really, again, knowing who the members of your family are and what your general desire is for them, and that starts the process. If you have copies of your bank accounts or a copy of a life insurance policy or something other along those lines, that's always beneficial, but it's not required. If the will was valid in that other state, it's valid here as well. That said, when you live in Washington and you start to accumulate assets here in Washington, Washington law may provide some differences on how those assets are owned. Washington's a community property state, so that means if you're married, then you start creating different ownership types in your assets here in Washington versus a state that may be a separate property state where spouses can own things separately. So it's always a good idea, say you moved from Idaho and now you're living here in Washington, it's still a good idea to take a look at things, make sure that there aren't any nuances with Washington that you need to update on your will.
Wonderful. Well, again, thank you all for coming out on this snowy night, and let's give Colleen a big hand.